start going like 2 steps back, usually when we talk about geographical indications and the relationship with trademarks. As pursuant to Article 5 of the Regulation 1151 2012, a designation of origin we know is the name that identifies a product which originates in a specific place, region, or even in exceptional cases a country. We know that, whose quality or characteristics are essentially or exclusively due to a particular geographical environment with its inherent natural and human factors. And where we're talking about designations of origin, where the production steps of which all take place in the defined geographical area. All production steps, we know that. Geographical indication is the name that, again, identifies a product originating in a specific place, region, or country, whose given quality, reputation, or that other characteristic is essentially attributable to that geographical origin, but at least one of the production steps takes place in the defined geographical area. Therefore, and I'll stop here just a second to allow the translators to stop me if I'm ever going too quick, because I do tend to talk quickly. If the translators need me to slow down, hands up, please. So I'll continue. So the difference, where there is one, between PDOs and PGIs is that the former PDOs have a closer link with the area, right? In the foodstuff sector, for instance, PDO will be the term to describe foodstuffs that are produced, processed, and prepared, so all the steps in a given geographical area, using that recognized know-how. And a PGI will indicate a link with the area in at least one of those stages of production, processing, or preparation. Therefore, PDOs has a stronger link with the area. I'd like to introduce this, and I'll say why in a minute, but it's very important also to underline that the concept of GI, geographical indication, differs from what we call a mere geographical term, as for the latter, there's no link between a specific quality, a specific reputation, or a specific characteristic of the product and that geographical origin, with the result that it does not come within the scope of the corresponding regulations that we'll see in a minute. You see here the defined geographical area with a specific product, creating that link between number 1 and number 2, we get to the PDO and to the PGI. However, when I say we, the office, refer to in our guidelines or during this presentation today, I'll be referring all the time to geographical indications. Because for us, there's no, I'll explain it in a minute, there's no difference in between both PDOs and PGIs, and we'll see why. You see on the slide the registration process, and the EUIPO has no competence whatsoever for infringement. GIs interact at the office, with the office. The registration process you see consists of two parts, the ex parte and the inter parte proceedings. And you can see how GIs can come into the AG part in the examination period. That's what we will be tackling today. Okay, we also can have a GI serving as a base of during oppositions, which would be Article 8.6. But today we're going to be tackling a summary of Article 7. So what does Article 7, which is our absolute ground for refusal, say? Well, Article 7.1J of our regulation provides for the refusal of trademarks, EUTMs that are excluded from registration pursuant to national, EU legislation, which you see the first four, EU legislation, or to international agreements, the last one on the slide, to which the EU or the member state concerned is party, and that protect designations of origin or geographical indications, that protect geographical indications. When defining the protection given to these specific designations, the relevant regulations refer simply to protected or registered names, regardless whether the names refer to a PDO or a PGI. That is why I was saying that we do not make a difference between PDOs and PGIs. The EU regulations, remember, I'll go back to here, we've got 1308 for wines, 251 aromatized wines, 2019 for spirit drinks, and 1151 for agricultural products and foodstuffs. We also have GIs that enjoy protection in the EU through international agreements to which the EU is party through Article 71J, and we'll see that in a minute. On the, you see on the left, you have what the EU regulations cover, and they only cover the areas of the green column. That is what we just saw: the wine, spirit drinks, foodstuff, agricultural products, and aromatized wines. These are registered by the Commission through DG Agri and protected pursuant to EU legislation. And here we include international agreements. Other than that, we have national law of the member states, which are therefore only applicable for non-agricultural GIs. So those sections would include leather, stone, cutlery, carpets, etc. And these GIs would be administered by member states, depending on national legislation. In the Budge judgment, it was confirmed that the EU has exhausted its legislation on agricultural products. Therefore, that is the protection given by the EU legislation. And as I was saying, the non-agricultural would be administered by member states. We turn the floor now to the Geneva Act. And in fact, Council decision 2019 of 7 of October 2019 approved the accession of the European Union to the Geneva Act of the Lisbon Agreement on Appellations of Origin and GIs. And it entered into force on 26th of February 2020. This way, GIs from non-EU countries are protected at EU level through the Geneva Act, and these can form basis for objections pursuant to Article 71J, which is the examination part, and can be also relied on in opposition proceedings upon Article 8.6, which I was referring to before. So the same as if they were EU. As I was saying, the EU became a contracting party to the Geneva Act in 2020. The relevant GIs under the Lisbon Agreement, which are the relevant GIs? Article 7.1J, read in combination with Regulation 2019, applies to geographical indications which originate from a non-EU country, refer to products at European level, remember the green column, wine, spirit, drinks, aromatized wines, and agricultural products and foodstuff. So products protected at European level, European Union level, that have been registered in the international register and that have been granted protection in the European Union through this regulation, through Regulation 2019. Therefore, Geneva Act of the Lisbon Agreement is another route for GIs, for non-EU GIs to enjoy protection in the EU. A bit of flash on this, we know it's a multilateral system of registration, dated 1958, the Lisbon Agreement, but it just tackled appellations of origin And after 20th of May 2015, the agreement was modernized, and Geneva Act of the Lisbon Agreement expanded the scope beyond appellations of origin to all geographical indications, opening it up to intergovernmental organizations. The EU deposited the Act for Accession in 2019, 26th of November 2019. And since the EU was the fifth acceding contracting party, the Geneva Act entered into force on 26th of February 2020. Applications for international registration of GIs are filed with the International Bureau of EUIPO. The International Bureau publishes the international registration in the EUIPO bulletin and notifies it to the Commission. That is Article 5 and 6 of the Geneva Act. The Commission then publishes it in the official journal of the European Union and assesses it. So what are the relevant dates? In principle, the relevant dates for establishing what right is the earliest are the filing date of the UTM application, or the priority date if claimed under the Paris Convention, and the date on which the application for the international registration of the GI was received by the International Bureau. However, Article 10 of the regulation that you see on the slide, 2019, allows for the coexistence of a protected GI and a trademark that has been applied for or registered in good faith within the European Union before the date on which the International Bureau notified the Commission of the international registration of the GI. In other words, a trademark application which is filed in good faith after the date when the application for international registration was received by the International Bureau, we're talking about the GI application, but before the notification of the publication of the registration to the Commission, will not be objectionable as the trademark can coexist with the GI. In the absence of any evidence or indication on the contrary, via third-party observations or inter-parties proceedings, the office will assume good faith on the part of the trademark applicant, the trademark applicant or proprietor. Put you on slide a few of the GIs from non-EU countries in the EU. Some GIs registered directly, like tequila or Café de Colombia, and some via international agreements with the EU. So we've seen Article 7, 1J, and we've seen the different regulations covered, the EU regulations. We've seen the different ways of protection also, the non-agri and the agri, and we've seen the international applications too. The EU regulations refer mutatis mutandi to different situations of use against which GIs are protected. You see, I've grouped them here in three big chapters. The EUTM uses the GI, that is, it consists solely of the whole GI or contains a whole GI plus another word or another figurative element. In respect of products which do not comply with product specification, or insofar as such use exploits the reputation of the GI. Second part is the UTM application contains or consists of misuse, imitation, or evocation of a PDO or a PGI. And then we've got other misleading indications or practices. So if you see this, in light of what I've just explained, there's 3 cumulative conditions that are to be met for Article 7.1J in combination with the EU regulations to apply. So the GI in question, be it from an EU member state or from a non-EU country, must be registered at EU level. Use of the trademark, use of the EUTM must constitute one of the situations provided for, the situations that I have just explained that you can see on the slide. And the EUTM application must include the relevant goods. Why? GIs are protected not only as regards trademarks applied for in respect for identical products to the product covered by the geographical indication, but also under certain circumstances as regards comparable products, as regards those applied for in respect of comparable products. But I will explain this. While GI protection against comparable goods is automatic in situations of direct or indirect use, the first part that you see here, the direct use, there's no such automatic protection in cases of evocation. We will see what the courts say in each of these cases. Consumers must also establish a link between the term used to designate the product, we're talking about the trademark, and the product whose designation is protected. In establishing the link, the degree of proximity of the product will be one of the factors to be taken into account. But as a consequence, it is necessary to assess, given all the different factors, whether a link will be established in the mind of the relevant public. Not sure what cases is Ms. Virginia Melgar going to be tackling tomorrow, but I couldn't give this presentation without giving you a few hints of what the court has said. And as the Court of Justice in the Queso-Manchego case, C614/17, it set a graduated list of prohibited acts. So paragraph A that you see on the slide would be limited to use of the protected designation of origin or protected geographical indication. Paragraph B would be misuse, imitation, or evocation. And C and D, which I've grouped together, these false or misleading indications and any other misleading practices. It is in the office opinion that the graduated nature of that list refers to how direct, or on the contrary, how subtle the reference to the disputed designation is to the protected name. Therefore, the most direct reference to the protected name occurs with acts falling under letter A. You see them, direct or indirect use. The most subtle reference to the protected name will occur with acts falling under the letter D, any misleading practices. Neither exploitation, the second part of A, exploitation of reputation, or evocation of the PDO-PGI contain any explicit mention as to the type of goods or services in respect of which the infringing acts may occur. So we see the 3 cumulative conditions of Article 7.1J. 3 cumulative conditions for Article 7.1J to apply. We've seen them, we've said it before. Has to be registered GI. There has to be a conflict with the GI, and we're talking about identical and comparable products. So where do we check if it's registered? We've got eAmbrosia administered by the Commission, and we've got GIView administered by the Office. The same database, just that GIView is perhaps an enhanced database, an enhanced details containing more information than what eAmbrosia includes. I've put the links there in case you wanted to go and have a look later on. So Article 7.1J, in combination with the EU regulations, we know that will apply where the GIs have been registered under the procedure laid down by the regulations that we've mentioned before. But protection is granted solely to the name of a GI as registered. We're not talking about an extension ipso iure to the names of sub-regions, sub-denominations, local administrative areas, or localities in the area governed, covered by that geographical indication. So what are the prohibitions? I've put them here on a slide so you see well, the link to the different regulations, the terminology, what we are talking about, the graduated list of prohibited conducts from the most direct link to the most subtle link with a geographical indication. We've seen that they apply in situations of registration or commercial use. And how does the office interpret these? The office interprets them to set a high degree of protection of geographical indications, but it's important that there's a balance of rights in the sense that the balance needs to take into account the effective protection of the GIs and the rights of bona fide trademark applicants. So there must be a balance of rights in this sense. We've seen, if I go one slide back, there was 3 cumulative conditions. We saw how we check if it's registered. We've seen that. What about the conflict with the GI? The different courts have been interpreting these concepts. For instance, I've selected 2 here in Scotch whisky. The Scotch Whisky Association contested the marketing via website of whisky not being Scotch whisky, which was sold under the designation Glen Buchenbach. And the ECJ addressed the conduct under Article 16, A to C, which is commercial use, evocation based on conceptual proximity, and misleading indications and context of use. According to the court, the word use requires by definition that the sign at issue makes use of the protected geographical indication itself in the form in which that indication was registered, or at least in a form with such close links to it in visual and in phonetic terms that the sign at issue clearly cannot be dissociated from it. This was said in Scotch whisky. But think of a mark that just consists of the GI. If the mark consists solely of the GI, the trademark also falls under Article 7.1c of the regulation, descriptive terms, since it will be considered descriptive both of geographical origin of the goods and of their quality. This means that the office objection will simultaneously raise absolute grounds for refusal under both Article 7.1c and Article 7.1j. I was saying before, sometimes you can restrict the relevant goods so they comply with the product specifications of the geographical indication. But while that restriction could be all right or efficient for waiving an objection under 7.1j, it will be relevant for Article 7.1c of the regulation. We'll see an example in a minute. We also have queso manchego. I already tackled that a minute ago. And in queso manchego, the queso manchego Foundation invoked Article 13b of the corresponding regulation against labels bearing the word Rocinante and including pictorial elements typical of the region of La Mancha, used to market cheese not conforming with specifications of the PDO Queso Manchego. What did the court say? That a registered PDO may be evoked through the use of figurative signs, such as the image, of the character, the literary character Don Quixote de la Mancha, irrespective of whether the goods originate from a producer in that region, but whose similar or comparable products do not comply with the PDO. So we're seeing the evocation through the use of figurative signs confirmed by the court. So I've put in a slide the different chapters, the different situations of conflict. So for the purpose of finding whether or not there's use of a GI, I've already said it here clearly in one slide. The office will assess whether a trademark, an EUTM, contains a GI as a whole or in combination with another element, but as a term that could be considered phonetically or visually highly similar thereto. In Scotch whisky, that I just referred to, direct and indirect use merely refer to the physical manner in which the use of a GI appears on the market. Direct use implies that the GI is affixed directly to the product, or on its packaging, while indirect use requires the GI to feature in supplementary marketing information sources, such as an advertisement for the product or documents relating to it. However, the distinction plays no role for the absolute grounds assessment, as the office is not concerned with the subsequent placing on the market of the mark proposed for registration. The use of the terminology, the use of terminology in the regulations and agreements does not mirror trademark language. The GI regulations contain references to different expressions, but the office interprets all of them as synonyms of comparable goods. Beer and wine, for instance, are not comparable products, although according to our practice, they're similar for trademarks. I've put two examples here. You see in the first slide, Chateau Beauregard, Pomerol, for goods and services, well, goods and services are wines, and the potential conflict with the geographical indications Pomerol. However, in this case, this would be a direct example of use, the GI direct use on the trademark, but the applicant limited, stating that the goods comply with the specifications of the geographical indication, and then the application can be registered and was registered, as in this case. Sorry. Another case is Champagne Demier for goods and services, inter alia class 33. So, but the applicant directly, applied for wine conforming to the specifications of the protected designation of origin Champagne. So although there's a potential conflict with the PDO Champagne for wine, this was registered as the applicant correctly designated the goods in class 33. Another example that I wanted to select was of identity that falls under use is Pepitas de Granada, inter alia for, well, agricultural products, non-alcoholic and alcoholic beverages. Potentially issue would be the conflict with the potential conflict would be with the geographical indication Granada. But Granada for wines, if we're talking about agri-products, non-alcoholic and alcoholic beverages. Well, in Spanish, Granada refers both to pomegranate and to the geographical place in Andalusia. In the sign, the reference to Granada is clearly to the fruit, so there's no conflict, and the trademark was accepted. We turn the floor now to the second part of the situations of conflict. And here we have misuse, imitation, and evocation. We understand that the mark imitates, mimics, reproduces elements of, etc., with the result that the product designated by the GI is evoked. It is called to mind. The term evocation requires less than imitation or misuse, as confirmed by Cambozola, c. 8797. Nevertheless, the office considers the terms imitation and evocation as two corollaries of essentially the same concept. However, in the absence of any guidance from the court, the office considers that a trademark misuses a GI when it provides false indications. I've put them in the slide separately. When it provides false indications as to the geographical source of the goods, with the result that it benefits from the perceived quality of the GI. That is for misuse. There will be imitation as a common meaning of the term when the trademark is intended to simulate, intended to copy something else. And by contrast, evocation is objective. There's no need to show that the owner of the mark intended to evoke the geographical indication. According to the court, the decisive criterion for finding evocation is whether, when the consumer is confronted with a disputed designation, the image triggered directly in his mind is that of the product whose geographical indication is protected. Consumers, we're talking about evocation, and I said this before, consumers must establish a sufficiently clear and direct link between the term used to designate the product and the product whose name is protected. At the same time, it's necessary to take into account the presumed expectation of the average consumer, who is at the same time reasonably well-informed, reasonably observant, and circumspect. In particular, not enough if the term incorporated in the trademark application evokes in the relevant public some kind of association with the protected geographical indication, because that association does not necessarily establish a sufficiently clear and direct link between that element and the indication confirmed. I will insist that what has to be found is that the relevant public establishes a sufficiently clear and strong link between the element of the EUTM and the GI, with the result that upon encountering the trademark, the image triggered directly in the public's mind is that of the product whose geographical indication is protected. In assessing whether such a link is established, the court has considered a few factors. For instance, whether there is a visual, phonetic, or conceptual relationship between the terms. For instance, if the terms share a characteristic beginning, such as Parmesan, Parmigiano, Reggiano, if the terms share characteristic roots or endings that have no particular meaning, Gorgonzola, Cambozola, Verlados, Calvados, or the degree of proximity of the goods concerned, that includes the actual physical appearance, as confirmed in Cambozola. The office first notes that the exploitation of reputation if you remember, within the first use, nor letter B, the evocation of a PGI, contain any explicit mention as to the type of goods or services in respect of which the acts may occur. We've seen that the degree of proximity of the goods is a factor, and that it includes the actual physical appearance. So, wrapping up, the criteria taken into account by the court is whether, you see it on the slide, there's a visual, phonetic, or conceptual relationship between the terms, the degree of closeness of the goods concerned, whether the part of the PDO PGI included in the trademarks forms a logical conceptual unit with the mark or not. But very importantly, evocation is not assessed in the same way as likelihood of confusion, as there can be evocation even in the absence of likelihood of confusion. Remember that what matters is in particular that an association of ideas regarding the origin of products is not created in the mind of the public. Let's see an example of evocation of Loro del Vesuvio that you see on the slide now, applied for inter alia tomatoes. The possible conflict was...
I'm sorry, Rebecca,
yes?
not to interrupt your very interesting presentation, but would you mind winding up in 2 minutes?
I think I've got very little to go now. Thank you.
Thank you.
So yes, the example here is Loro del Vesuvio, and there was no evocation found. It was applied for inter alia tomatoes. Possible conflict with the Pomodoro di Pianoro del Vesuvio, PDO. But again, there was a limitation to products complying with the specification in question, specification of the GI in question. So remember, there's 3 big areas. The last one is the false misleading indications or other practice. What is a test? Well, the test here is the office would therefore has to establish whether or not an indication is liable to convey a false impression as to the origin of the product or as to the nature of the essential qualities of the product. In the Scotch whisky judgment, the court addressed the issue of misleading indications, and there were 2 points considered. An indication could be considered misleading, may be considered misleading, if it includes information that is capable of providing information on the provenance, origin, nature, or essential qualities of that product. And I threw a question out there: are we extending that? Does it extend to the reproduction of the shape or the appearance which is characteristic of the product? And second, the context in which the possible misleading indication is used will not be taken into account. Obviously, given the inherent difficulty in identifying and assessing these possible indications, the office will rely principally on observations by third parties.
Thank you very much. That was a very interesting presentation. And I thought it was a good contrast with the first from Tara, because it gave the perspective of the European Union. That perspective is very relevant to us in the Caribbean, both from the point of view of providing best practice for our policymakers in terms of the regulation of GIs and TMs at the regional level and also the national level. And also the references to the European Court of Justice were very, very opposite, because the CCJ also has a referral obligation, referral jurisdiction. And of course, we can learn very much from the European Court of Justice as to how they went about interpreting these regulations and these cases. Thank you once again very, very much.